Hello everybody. I thought a short revision lecture might be useful as you prepare for your exams. It's hard to know exactly what needs to go into a revision lecture, but certainly one useful thing to look at is recent developments. So I'll start there. What recent developments you need to know about depend obviously on what the syllabus of your course is. So there might be things that I'm not covering here, in which case I'm sorry. You might find them somewhere else. But I'm going to go through what appear to be the most important recent developments up to the middle of February and set them in context, so perhaps you'll understand the importance of them a little bit better than if you just read about them in a vacuum. I'll try and cover the basics that you need to know for the exam and some exam tips in other lectures, and I'll try and keep this as general as possible rather than limiting myself to any particular institution's syllabus. So I'm not going to try and cover everything you need to know. It's a bit late to go back to basics now anyway, and I'll try not to cover stuff that you won't need for the exam. I don't anticipate examiners asking questions about Brexit and its implications for intellectual property or about the Trade Secrets Directive, but I'm working on a presentation about Brexit, which if you need to know about it ought to give you a bit of assistance. Nor am I going to indulge in any question spotting. Well, if I'm being course neutral, there's no point in trying to do that, because what's going to work for one institution isn't going to work for another. But one thing that will come out of this presentation is that there are some important cases which, were I setting an exam, I would introduce into the questions. I think slipping something about one of these recent cases into the exam is an excellent way of identifying the really good students. So with a bit of luck, that's going to be you. So let's start with confidentiality, and we've got a recent-ish Court of Appeal judgment on what constitutes public interest in this area. So it's an interesting, very important topic, a justification for disclosure of information which otherwise is confidential. Remember, here's a little tip for you. Well, I'm sure you don't need me to tell you this, but when you're writing about confidential information, your starting point is always going to be that wonderful case Coco and Clark, and the three elements which the judge, Mr. Justice McGarry as he then was, identified as being crucial in a breach of confidence case. The information must have a characteristic of confidence about it, there must be an obligation of confidentiality, and there must be damage, the classic trinity. So as far as public interest is concerned, about 12 years ago the Court of Appeal gave judgment in the Associated Newspapers and Prince of Wales case and told us that whether the public interest justifies a disclosure of otherwise confidential information is not a question of simply whether or not the information was a matter of public interest, but a much more serious question whether it was in the public interest that the duty of confidence should be breached. Information which is a matter of public interest will sell newspapers, but that's not a valid reason for overriding the duty of confidence associated with it. In this 2017 case, Reverend Howard Asset Management against Reuters, the Court of Appeal applied its earlier ruling and upheld the decision which had been arrived at by the trial judge. The Court of Appeal said that the judge had rightly taken into account the importance of maintaining confidentiality in financial information when he'd assessed the proportionality of an order to restrain disclosure. It's a pretty clear statement of when it will be in the public interest to override a duty to keep financial information confidential. The judge had issued an order restraining disclosure. Reuters had appealed, and the Court of Appeal upheld the judge dismissing the appeal. Now I'm going to move on to deal with patents, and actually I think it's a good idea to do so before your attention wanes at all, because this is where we've got two really important cases. Let's talk firstly about compensation for employee inventors. You'll remember, I hope, that an employee who's invented something may be awarded compensation for a patented invention of which they're the inventor, but they're not the owner, by virtue of section 39 subsection 1 of of the Patents Act 1977. And you'll also remember, I hope, that Section 39(1) deals with two different situations. First of all, where the employee is basically employed to invent, and then secondly, where the employee is employed in such a role that they have a special duty to promote the undertaking of their employer, which means probably that they're a director, but it's not necessarily limited to directors. You'll also remember that Section 40 provides for the payment of compensation where the invention or the patent for the invention, remember it covers both those situations, is of outstanding benefit to the employer, and it's just for an award of compensation to be made. If you're answering a question on this topic, make sure you let the examiner know that you appreciate that both those legs have got to be satisfied. And I guess you're also well aware from your reading that almost nobody ever gets compensation. There aren't a lot of cases to point to about this, but in 2017 we had the Court of Appeal's judgment in Shanks against Unilever, which considers two important elements of the test for whether compensation should be payable. First of all, how to assess the value to the employer, and the court said, take no notice of the fact that the benefit to the employer is received some years before the hearing which considers whether an award of compensation should be appropriate, nor do you take any account of the fact that the financial benefit applicable to the patent or invention will be taxed in the employer's hands. So those are principles that you apply when you're working out how much the employer's benefit is worth. The next question is whether that benefit is outstanding. The benefit was valued at £24.5 million, and in many contexts that's a pretty outstanding amount of money. But remember the key decision in this area, the British Steel case, which was a patent office decision, so not a decision of the High Court or anything, which basically turned on the fact that in a huge organisation like British Steel, even if the invention produces savings of hundreds of thousands of pounds, that's a drop in the ocean compared with the organisation's turnover. Unilever is also a big organisation, and for that reason 24.5 million was not outstanding in this instance, but it's more than simply a matter of comparing the value of the benefit with the size of the undertaking. The argument in the Court of Appeal was whether the hearing officer in the Patent Office had done what he was supposed to do, which is to apply a multifactorial approach as required under the statute. One factor, of course, will be the size and nature of the employer's business, but that isn't, and it must not be, the end of the story. Otherwise the rule simply becomes a too big to pay rule, which of course wouldn't be advantageous to employee inventors at all, as if Section 40 is ever very advantageous to them. Though in the Court of Appeal's judgment, Lord Justice Briggs acknowledged, in the words that I've included in the slide, this does appear to be a case in which the sheer size of the employer's undertaking was, at the end of a careful and balanced analysis by the hearing officer, the key factor in his conclusion that the benefit which Unilever derived from Professor Shanks's invention was not outstanding within the meaning of that word in Section 40, subsection 1 of the 1977 Act. It may be going too far to say that Unilever was simply too big to pay, but there is no escaping the fact that Professor Shanks might well have succeeded had his employer had a much smaller undertaking than did Unilever. This decision was handed down in January 2017, so it was in plenty of time for an examiner who's probably got to write the exam in the autumn of 2017 to build a question around it. Actavis against Eli Lilley and Co. is a little more recent. That was July 2017, but still in plenty of time for the examiner to think about it during the summer vacation and put it into an exam. It would feature in lectures, of course, but it's not going to get into textbooks quickly enough. And because it's a Supreme Court judgment and because it changes a fundamental area of patent law, you've really got to know about it. So there is some interesting technical features of the case, but they're not really what you need to know about it. It concerns what's known as a Swiss-style claim. Basically, this is a second medical use for a known compound. So you knew that a compound would have one therapeutic effect, then you discover it's got another therapeutic effect as well, so you can get a second patent for it. The compound concerned is pemetrexid disodium, which has to be used in conjunction with vitamin B12 because that overcomes some of the side effects of it. It's used in the manufacture of a medicament for treating cancer. All this chemistry can seem very daunting, but just keep remembering that actually the law isn't very complicated. Now, of course, a lot of the cases that you read get to court because the owner of the patent sues for infringement. This case gets to court in very much the opposite way. Actavis go to court asking for a declaration that they wouldn't infringe if they market drugs which contain other pemetrexid compounds. And in particular, they were interested in using a potassium salt rather than a sodium salt. At this stage you might wonder why, if a potassium salt will do the job, Eli Lilly applied for a patent specifying sodium. If that thought has crossed your mind, then just keep it there for a moment. If it hadn't crossed your mind, well, it has now, hasn't it? So this becomes a matter of interpreting that patent claim. And when you're considering whether there would be an infringement, you've got two elements to that. You've got the question of whether there's an infringement in law, whether what Actavis are proposing to do is the sort of act which could amount to an infringement. They want to market drugs. That's fairly clearly within the scope of what amounts to an infringement of a patent. So then you go on to consider whether there would be an infringement in fact. Is what they're doing within the scope of Eli Lilly's exclusive rights? And those exclusive rights are determined by the claims. But as you know, not just by the words of the claims, because for many years the courts have proceeded on the basis that patent claims are not documents to be interpreted literally. Historically, there are lots of fun cases going one way and the other about how to interpret patent claims, but ever since the Kirin Amgen case, which is now about 12 years old, we've known that to interpret patent claims, the only document you need to look at for guidance is the Protocol on Interpretation of Article 69 of the European Patent Convention. And the protocol says you don't just interpret the claims literally, although having said that, if what the defendant has done is a literal infringement, then you don't need to ask any more questions. That's the way that before the protocol was formulated, the English courts often used to approach things, nor do you treat the claims just as guidelines, which is how some continental courts, and I think particularly the German courts, used to approach matters. So the protocol is saying, find a path between those two extremes and strike a balance between the interests of the patentee, the owner of the patent, and the user of the invention, the would-be infringer. In that case, this is Actavis, and what somebody in Actavis's position would like to be able to do is to look at the patent claims and say what we're doing is outside the wording of the claim, and therefore we know that it's not going to infringe. If you have a literal interpretation of the claims, you get maximum legal certainty. So in this case, they'd look at it and say, well, it says sodium, we're going to use potassium, therefore we're not infringing. From Eli Lilly's point of view, the further you can get away from a purely literal interpretation of the claims, the better. If they can establish that somehow sodium might magically include potassium, or the courts would recognise that potassium will be equivalent to sodium, that would be really good. So when the application for a declaration came before the courts, Mr. Justice Arnold at first instance had to follow the Kirin Amgen case. It was a decision of the House of Lords. He didn't have any choice about it, and that meant that he applied the protocol. and on that basis he gave the declaration that Actavis wanted. The Court of Appeal was similarly bound by Kirin Amgen, so the Court of Appeal upheld his decision. Then the case arrived in the Supreme Court, where Lord Neuberger gave the leading judgment. He is not baffled by all the chemistry, like I am, and he said that when a court has got to consider a possible infringement by a variant, this is what this area of law is all about really, variants, there are two questions that the court's got to ask. First of all, does the variant infringe the claim at issue as a matter of interpretation? So you could say, I think, taking a literal interpretation of the claim, in other words the narrowest interpretation, the most favourable to the defendant interpretation, is there an infringement on that basis? The protocol says you don't want to have a purely literal interpretation, but looking at it from the defendant's point of view, if they infringe on the basis of a literal interpretation, then whatever other way of interpreting it you adopt, it's even more going to be an infringement. But if the variant doesn't infringe as a matter of interpretation, you've got to go on to ask whether the variant infringes because the variations in it are not material. Or, putting it another way, the question is whether the variant is equivalent to the claimed invention. Is potassium equivalent to sodium? Prior to Kirin Amgen, the courts had devised a series of questions which the judges were supposed to ask themselves in order to work out whether a variant fell within the terms of a claim. They were known originally as the improver questions after the case in which they were first formulated by a new High Court judge called Mr. Justice Hoffman. They later came to be called the protocol questions because the protocol on the interpretation of Article 69 became the key document, and the questions were seen as a useful aid to applying the rules in the protocol. But in the Kirin Amgen case in the House of Lords, Lord Hoffman, as he'd become in the interim, had to say these questions are no longer relevant. The only thing that you have to do is apply the protocol. In Actavis, Lord Neuberger is saying that the questions are still useful when you're asking that second question about whether a variant infringes or not. However, they needed to be changed slightly, so the questions become, first of all, does the variant have a material effect on the way the invention works? If it does have a material effect, then it's not going to infringe, it's outside the scope of the claims. Secondly, if it doesn't have a material effect, whether the notional addressee, on learning what the variant does, would consider it obvious that it would achieve substantially the same result in substantially the same way as the invention. And then finally, whether the notional addressee would have understood from the language of the claim that the patentee intended strict compliance with the primary meaning to be an essential requirement of the invention. So here, does using a potassium salt instead of a sodium salt have a material effect on the way the invention works? No. Would the notional addressee, this is the hypothetical skilled person, on learning what the variant does, consider it obvious that it would achieve substantially the same result in substantially the same way as the invention? Would it be obvious that potassium would work just as well as sodium? And finally, would that same skilled person have understood from the language of the claim that when the patentee said sodium, that was an essential requirement of the invention? But note from my summary a couple of slides ago that Lord Neuberger was talking in terms of potassium being the equivalent of sodium. There is in patent law what's called a Doctrine of Equivalents. It's lurked around in UK patent law in the past. There was a Doctrine of Mechanical Equivalents years ago, and in the United States it's quite important. But it's been almost an article of faith in UK patent law that there is no Doctrine of Equivalence in UK patent law, and that was made plain in the Kirin Amgen case. However, it's not possible to be quite as dogmatic about it anymore, because the protocol on the interpretation of Article 69 has been amended, and a second article introduced, and I'm sure you've got it in your statute books, but Article 2 says, for the purpose of determining the extent of protection conferred by a European patent, due account shall be taken of any element which is equivalent to an element specified in the claims. So Article 2 of the Protocol makes the existing position of the English courts that there is no doctrine of equivalence quite untenable. In effect, potassium was equivalent to sodium for the purposes of the patent, and therefore Actavis would infringe if they marketed the products, and therefore the declaration which Mr. Justice Arnold had given at first instance and which the Court of Appeal had upheld was overturned by the Supreme Court. It's hard to underestimate the significance of this decision, not only in the practice of patent law but also in examinations, and it lends itself to essay type questions and also to problem type questions. So the implications of this judgment, to summarise, are that the courts have probably moved a little further away from a literal interpretation of patent claims, and therefore introduced a greater degree of uncertainty for those who want to operate in the field without infringing. You might come across the expression freedom to operate, which is all about looking at the patent landscape and working out whether you're going to infringe anybody's rights if you do what you're planning to do. The protocol rejects a literal interpretation of the patent claims, and one of the advantages that's put forward for this approach is that it enables the claim to be read in the light of technological developments. So I don't know what's happened in this area of technology, but it could be that Eli Lilly got their patent specifying the sodium salt because that's what they knew worked on that particular day. Sometime later they might have found out that potassium worked just as well. Clearly Actavis found that potassium worked as well. So the possibility of using potassium instead might be a technological development which has happened since the patent was granted. And the further removed you are from interpreting the patent claim literally, the more you are future-proofing the wording of the claim against technological developments which come along later. So if you have an examiner who's asking you to discuss this topic critically, you might be inclined to say, this is being unduly generous to the patentee. Is it right that if Eli Lilly chose to specify a sodium compound when perhaps they could have used broader language, or they could have put potassium as an alternative, should they receive such an extensive and flexible monopoly? Is it right that the patent system extends their protection beyond the sodium salt to include the potassium salt and possibly other metal salts as well? Wouldn't it be better for all concerned if the patent system said, you can have exclusive rights over the sodium salt, that's what your invention is. If somebody discovers that a potassium salt or some other compound will do the job in the future, that'll be a new invention and it can be patented in its own right. It might be an invention that's highly dependent on the earlier invention by Eli Lilly. So the inventor of the new compound might need a license from them to work their invention. But that might seem to you to be a much more rational way of approaching these things and saying, okay, well, you said sodium in your patent, but we all know that that's because you didn't know at that time that other compounds were going to work, so let's just pretend that when you said sodium you were including potassium and anything else that would do the job. It seems ironic that in an area where precision and accuracy is so important, or I should say in areas because it's science and it's law, in this one part of the field the courts should throw legal certainty out of the window and be as flexible as they can. Well, that's exaggerating the issue slightly, but I hope it shows you that you could have a really interesting discussion about this. No presentation on intellectual property can make seamless transmissions from one area to another, so here's a big leap into copyright. And if you don't know Green against Broadcasting Corporation of New Zealand, the Opportunity Knox case, then you probably haven't been paying enough attention. And if you don't know what Opportunity Knox was, except that it's a television show, I found an episode on YouTube and I've added it to the copyright playlist on the ipso jure channel, so you can have a look at it. And the thing about the program is that there is nothing in it that the courts could recognise as a copyright work. That's why Huey Green failed to prevail over the Broadcasting Corporation of New Zealand when they produced their own version of the program. I think it was a bit of a wake-up call to companies that make television programs, because they're much more aware of the need to make the most of what intellectual property rights they have, and to maximise their protection. So while there is no law that says you've got any rights of any sort, whether copyright or anything else, in a television program format, nevertheless there are ways in which you can get round that, and actually using a lot more than just copyright, because there are many elements in, for example, a game show, and that's what we're talking about here in the Green case, and also in the new case, Banner Universal Motion Pictures Limited against Endemol. Lots of elements lend themselves to being protected by registration as trademarks, and there are elements of the set that will be protectable as registered designs. So you're not just looking at the possibility of having copyright in a dramatic work. However, that's basically what Banner involved. Mr. Banner had an idea for a TV programme, and he'd written it down, and he argued that that was a dramatic work. There was litigation in several different countries, and I think Mr. Banner was Danish, so he'd been talking to broadcasters in a lot of different places. Anyway, it came before the High Court, and Mr. Justice Snowden said that a format for a television programme could be protected. Mr. Banner's claim wasn't a complete non-starter, but he'd have to show that the programme had certain minimum characteristics. The judge said there had to be a number of clearly identified features which distinguished the programme in question from others of a similar type, and that those distinguishing features would have to be connected with each other in a coherent framework which could be repeatedly applied so as to enable the programme to be reproduced in recognisable form. Obviously these shows aren't exactly the same from week to week. That would rather spoil the purpose of making them, but there are elements which are recognisably the same. In the Green case, these characteristics were lacking, and therefore the claim failed. In the Banner case, the judge told us that if these characteristics were present, there might be protection, but again, they were lacking, and therefore the claim failed. So the important thing about the Banner case is that it leaves the door open for television programme formats to get some protection, and explains about how they might be able to secure that, but it doesn't yet provide us with an example of a claim that succeeded. Next, a case on hyperlinking. Putting in a hyperlink to an infringing copy of a copyright work on the internet is hard to distinguish in economic terms from loading a copy onto your own server and allowing people to download it from there. So not surprisingly, the Court of Justice has told us in the Svensson and GS Media cases that linking to a copyright work amounts to a communication to the public under the Information Society Directive, and therefore if the copy of the work to which you're linking is unauthorised, then you too may be committing an infringement. Now we have this new case, Stichting Brein against Willems, or Filmspeler. I think my Dutch pronunciation is probably terrible. I guess that means something about film player, media player. It concerned the distribution of a media player device which had preloaded links to websites that carried infringing materials. So the Court of Justice has extended the principle which is established in Svensson and GS Media and said that too amounts to a communication to the public. In the GS Media case, the link was to specific infringing works. In Brein, the links were to sites which had unspecified infringing works on them. So it's a considerable widening of the basic principle that the court had already established. And it's probably easy to see why at least copyright owners will see it as a necessary widening of the scope of the action. Now for another sideways leap into a different area of intellectual property law, design right. The Intellectual Property Act 2014 made several changes in this area of law. One of the important changes it made was to amend the definition of a design, which you find in section 213 of the Copyright Designs and Patents Act. The definition used to have the words any aspect of in it. Design means the design of any aspect of the shape or configuration, whether internal or external, the whole or part of an article. It took out those words any aspect of, arguing, I think, that nobody really knew what they meant, and it didn't seem to add very much. And it was especially confusing when the definition also talked about parts of the design. So what's the difference between an aspect and a part? Mr. Justice Carr has now explained this for us in a case called Neptune Europe Limited against Devold Kitchens Limited, and perhaps he's excited the attention of the examiner. It's certainly an obscure enough topic to make an interesting essay question, perhaps of the right about 2 out of 4 of these topics variety, and it's also very definitely the sort of issue that arises in problem questions, which frequently seem to involve lids for things. So Mr. Justice Carr has said, in my view, aspects of a design include disembodied features which are merely recognisable or discernible, whereas parts of a design are concrete parts which can be identified as such. Returning, he said, to the example of Mr. Justice Laddie in Ocular Sciences, aspects of the design of a teapot could include the combination of the end portion of the spout and the top portion of the lid, which are disembodied from each other and from the spout and lid. They are not parts of the design. So the question seems to be whether the features that you're considering are disembodied or embodied in the design, and that's how you distinguish a part from an aspect. I think we need a lot more cases before we can really say with clarity how this works, but there's enough going on here for the examiner to show an interest. The Neptune case also helps us to work out whether the changed definition has retrospective effect, and this is something that the parliamentary draftsman evidently didn't even think about at the time. The key date on which the amendment came into operation was the 1st of October 2014, so any causes of action which arose before then can be based on the old, broader definition of design, which included any aspect of the design. So if the infringement was committed before then, even if you're suing now, you should be able to work on the broader definition. On the other hand, if infringement claims are based on activities taking place after 1st of October 2014, they've got to be assessed under the revised law. And the fact that the design might have been created before the Intellectual Property Act came into force isn't going to make any difference. You'll find that all set out in paragraphs 29 to 42 of Mr. Justice Carr's judgment. The next topic, still to do with design right, by which I mean what is often now called UK unregistered design right, but it's still just design right as far as the Act is concerned. The next topic is how you deal with the excluded elements of a design, and in particular we're talking here about must fit and must match features, and also methods of construction. The question is, do you treat these excluded elements in the same way as you treat commonplace features? And the answer, somewhat unsurprisingly, is no. That answer is found in a case called Action Storage Systems Limited against GeForceEurope.com Limited. It's a judgment of His Honour Judge Hakon, and I've paraphrased what he said somewhat on the slide. His first point is that excluded features should be disregarded when you're considering whether an infringement has taken place under section 226. The excluded features simply don't form part of the design for those purposes. Taking them out of the equation might lead to the situation where what you've got left is no longer a design of the article or part of an article, which is an interesting possibility, a bit of a sideshow. It doesn't form part of the important question, which is how you deal with these excluded elements. Anyway, when you consider commonplace features, Section 213 subsection 4 applies to the design as a whole. It's not concerned with individual features of a design. So with the excluded features, you subtract them from the design before you work out what's protected. With any commonplace elements of the design, commonplace features, you leave them in the design when you're considering what's protected. The question of what's commonplace relates to the design overall, not to individual features. So when you come to judge whether an infringement is taking place, you look at the whole design, including commonplace features. It's only if the design as a whole is commonplace that you've got problems. Now for trademarks, beginning with an important case on acquired distinctiveness. And you'll remember that acquired distinctiveness is important because it can overcome some of the relative absolute grounds on which trademark registration can be refused. If the trademark's devoid of distinctive character, if it's descriptive or if it's generic, then acquired distinctiveness can overcome those problems. The applicant can demonstrate to the satisfaction of the examiner that their non-distinctive or descriptive or generic matter has come to distinguish their goods or services by virtue of the use they've made of it. And generally speaking, incidentally, the examiner will be looking for about 2 years' use, although it's going to vary very much from one type of product and one type of trademark to another. The case here is a Court of Appeal decision, Société de Produits Nestlé against Cadbury UK Limited. There is a bit of a war going on between these parties. Large numbers of trademark cases involving things like the colour purple used by Cadbury's, and in this particular case the shape of the Kit Kat biscuit, chocolate biscuit, bar. It looks as if there's a bit of a tit-for-tat element to this. Nestlé beat Cadbury on the purple colour, so Cadbury have a go at Nestlé over the shape of the Kit Kat. The basic principle is easy enough. An inherently non-distinctive trademark will only acquire distinctive character where a significant proportion of the relevant class of consumers come to perceive goods designated by the mark as originating from a particular undertaking. The basic purpose of a trademark is the indication of origin. So to make a non-distinctive trademark registrable, you educate the relevant class of consumers to recognize it, not just as something non-distinctive, but something which identifies you as the maker. The big problem with the Kit Kat shape is that you can't see it until you've bought the product and you've taken the wrapper off. Obviously that's not the way that trademarks normally work. The idea of a trademark is that it has its effect on the purchaser's mind before the moment of sale, and that's obviously not happening with the shape of a chocolate biscuit that's wrapped up. Nestlé's overcome this to some extent by putting a picture of the fingers on the wrapper, but that's certainly not a complete answer to the problem. Of course, Nestlé are able to say that a significant proportion of the relevant public recognises the mark, they recognise the 4 fingers, and they associate it with the applicant's goods or services, with the Kit Kat bar. I think anybody with any experience of chocolate would be able to recognise that proposition. The point is, the court says that's not enough. On the other hand, the applicant doesn't have to show that the public has actually come to rely on the mark as an indication of origin. It's more a matter of what the mark can do than what it actually does do. But if the public does rely on it as an indication of origin, then that's going to be very helpful from the applicant's point of view. That would indicate that the public identifies the goods or services as originating from a particular source. The 4-fingered chocolate bar is a Nestlé product. The evidence in the case showed that the public did associate the shape with the product, but it didn't show that they perceived it as indicating goods from a single undertaking. Therefore, the 4 fingers weren't doing a trademark job, and distinctiveness was not being acquired. Adwords are a productive area of trademark law these days, have been for quite some time. The Court of Justice has had several cases, including the famous Google France case, and in Victoria Plum Limited against Victorian Plumbing Limited, Mr. Justice Carr, who's obviously been a busy man and not on the bench for very long yet, has had to consider it. I think the first time Adwords had been before the English courts. A claim of trademark infringement based on the defendant's bidding for Adwords based on the claimant's registered trademarks. That's the way Adwords work. You bid for your Adword and there's very little to stop you from nominating as your Adword your competitor's trademark. At least nothing in the Adwords system to stop that from happening. Then comes before the courts and of course all hell breaks loose. So Victorian Plumbing are bidding on the Adword Victoria Plum. Victoria Plum sue for trademark infringement. Mr. Justice Carr says that the defendant's advert doesn't enable normally informed and reasonable internet users, or enables them only with difficulty, to ascertain whether the goods and or services advertised originated from the trademark's proprietor, or from a business that was economically linked to the trademark proprietor. You probably get the feeling that some of that language could only possibly have come from a European Union institution, and indeed that's exactly the sort of terminology that the Court of Justice has used. It's a formula that's supposed to embody the sort of confusion that can take place in the Adword world, but it always seems very convoluted and to approach things from the wrong direction. The point is that internet users can't easily tell whose goods they're looking at. So that part of the case is simply applying principles that we know about Adwords. The second part of the case deals with honest concurrent use. It used to be a very important thing before the Trademarks Act 1994, which enabled two people to end up, or even more than two people, to end up with registered trademarks that were, to all intents and purposes, identical to each other, on the basis that they'd been using them in the past. And before 1994, the trademark registration system was all based on what people had actually used in commerce. Post 1994, the basis of the system is very different. Registration is the all-important starting point. So honest concurrent use becomes much less important, but it doesn't go away altogether. And as Mr. Justice Carr says in this case, any rational system of registered trademarks has to cater for the situation where two traders have coexisted using trademarks which have caused confusion for many years. Victoria Plum and Victoria Plumbing. But the principles recognised it in EU law, in one of the myriad Budweiser cases, where the Court of Justice said that where two separate entities have coexisted for a long period, honestly using the same or closely similar names, the inevitable confusion that arises may have to be tolerated. This will be the case where the trademark serves to indicate the goods or services of either of those entities, as opposed to one of them alone. In those circumstances, the guarantee of origin of the claimant's trademark is not impaired by the defendant's use, because the trademark does not denote the claimant alone. However, the defendant must not take steps which exacerbate the level of confusion beyond that which is inevitable, and so encroach upon the claimant's goodwill. So notice that the coexisting use has got to be honest. In the second paragraph, the court is almost saying that the trademark becomes a kind of joint trademark. It distinguishes the products of the parties from all the other brewers in the world, but it doesn't distinguish between the products of the parties themselves. The parties have just got to put up with this, unless something happens which exacerbates the level of confusion, and it goes beyond that amount of inevitable confusion that the parties have just got to put up with. That's all very well, but in the Victoria Plum case, the defendant couldn't say this is honest concurrent use for the simple reason that the whole problem was that they were using the claimant's trademark, not their own. I guess honest concurrent use would be quite important between the two parties so long as they stick to using their own trademarks, but obviously that was not what was happening here. And that brings me to one last case, which is actually a patent case, but because it's about the circumstances in which an injunction can be granted, it's applicable across the whole range of intellectual property rights. Always remember that injunctions, even final injunctions, are a discretionary remedy. an equitable supplement to the common law remedy of damages. So the case here is Edwards Life Sciences against Boston Scientific, and it concerned the use of a heart valve in medical procedures. Not a method of treatment, it's the valve itself that's the patented product, but using it in a medical procedure would amount to an infringement. The infringement has been established to the satisfaction of the court, and the judge is looking at remedies, and the patentee is saying, please give me an injunction to stop the infringement taking place. It's exactly what you would expect to happen in this circumstance. The complicating factor is that you've got a number of patients, a small number of patients, but still some, who need an operation to fit them with the valve in suit, the valve that's being sued over. It's the only one available to them, and if the injunction is granted, that's going to put their health at risk. The injunction's a discretionary remedy, and the judge says that public interest might not be served by granting an immediate final injunction. It could be that delaying the final injunction to allow these operations to go ahead is all that's necessary. But the point is that an injunction, being discretionary, is subject to this sort of consideration. I think that's a particularly good example of the sort of thing that can cause the judge to exercise his or her discretion. Right, that's all I've got for you here. I'll provide you with links to those cases so you can go and read them, should you wish to do so. It's probably a bit late in the course to be doing that. I'd be very pleased if you would subscribe to the YouTube channel here, and then you'll get to know when I upload more lectures. If this has been useful, please give it a like, and if you've got any comments, please leave them. I'd be particularly interested to know if there's anything else I can be producing at the moment to help with your revision. Thank you very much for listening, and I'll speak to you again soon.